Picture this. You are walking down the street, minding your own business. Maybe you are filming a building, or maybe you are just waiting for a friend. Suddenly, a police cruiser pulls up to the curb. The window rolls down, and the officer says 4 simple words, "Let me see your ID." Your heart starts pounding. You know you haven't done anything wrong. But you also remember hearing somewhere that you have the right to remain silent. So you ask yourself the million-dollar question, if I say no, am I going to jail? Most Americans believe that when a police officer asks for your papers, you have to hand them over immediately. They think it is the law. But the Supreme Court of the United States says, you might be wrong. And getting this wrong can cost you thousands of dollars, or even your freedom. Welcome back to Legal Loophole US. I am Mike. Today, we are going deep into the Fourth Amendment to answer the ultimate question, when can you legally tell a cop no? To understand your rights, you first have to understand the game. And make no mistake, it is a game with very specific rules. The courts have ruled that there are 3 distinct levels of police interaction. Level 1 is called the consensual encounter. This is where 90% of people mess up. A consensual encounter is just that, voluntary. An officer can walk up to you and say, "Hey, can I talk to you for a second?" Or, "Do you have some ID on you?" In this scenario, the officer is legally just a regular person asking a question. You have the absolute right to say, "No thanks," and walk away. But here is the trick, police are trained to make these requests sound like orders. They use a commanding voice. They stand in your path. But unless they have a legal reason to stop you, you are free to go. The problem is, most people are too polite. They hand over their ID voluntarily. And once you hand it over voluntarily, you have waived your rights. You just invited the government into your life. Now, let's move to level 2. This is the danger zone. It is called investigative detention, or a Terry stop. This comes from a famous Supreme Court case called Terry versus Ohio. The court ruled that if a police officer has reasonable suspicion that a crime is about to happen, or has just happened, they can briefly detain you to investigate. Notice I said reasonable suspicion, not a hunch. They can't stop you just because you look nervous, or because you are walking in a bad neighborhood. They need specific, articulable facts. During a Terry stop, you are not free to leave. If you try to walk away now, you will be arrested for obstruction or resisting. But here is where it gets complicated. Just because you are detained, does that mean you have to identify yourself? This is where the United States is split in half. You have probably heard the term, stop and ID state. In the US, about half of the states have laws that say, if you are lawfully detained, you must provide your name or ID. These are states like Arizona, Florida, Texas, and Ohio. In these places, if a cop has reasonable suspicion and demands your ID, and you refuse, you go to jail. Simple as that. But then, you have the other half of the country. States like California, New York, and Pennsylvania. In these states, there is generally no statute requiring you to identify yourself during a detention, unless you are actually being arrested for a crime. This means in Los Angeles, you could theoretically be detained, handcuffed, and investigated, all while refusing to give your name. And legally, they cannot charge you for the silence alone. This is why you see so many viral videos of people arguing with cops. They are often applying California laws in Texas, or Texas laws in New York. And that confusion is exactly what gets people arrested. Now, throw everything I just told you out the window, because we need to talk about cars. When you get behind the wheel of a car, the rules change completely. Driving is considered a privilege, not a right. If you are the driver and you get pulled over, you must provide your driver's license. Period. It does not matter what state you are in. It does not matter if you think you are innocent. If you are driving, you must ID. But, what if you are the passenger? This is the loophole. In many states, passengers are just cargo. Unless the officer has a separate reason to suspect you specifically of a crime, like seeing you hide a bag of drugs, or seeing that you aren't wearing a seatbelt, you often have the right to remain silent and refuse ID. The Supreme Court has ruled that passengers are detained, along with the driver, but that doesn't automatically trigger a requirement to identify yourself in every state. So, how do you know which situation you are in? How do you know if it is a consensual encounter or a detention? You can't read the officer's mind. So you have to ask. If a police officer starts asking you questions, asking for ID, or probing into your business, there is one magic phrase you need to use. Officer, am I being detained, or am I free to go? Memorize that. Am I free to go? If they say, yes, then leave. Immediately. Don't linger. Don't argue. Just walk away. If they say, no, you are being detained, then shut your mouth. You have now established that this is level 2. At this point, depending on your state, you may need to provide ID. But you do not need to answer questions about where you are going, where you came from, or what you had for dinner. The legal system is designed to be confusing. Police officers are allowed to lie to you. They are allowed to pretend you are detained when you aren't. They are allowed to pressure you. Your only defense is your knowledge. Remember, 1. Know if you are in a stop and ID state. 2. Ask, am I free to go? 3. Never confuse a polite request with a legal order. If you found this breakdown helpful, do me a favor and hit that like button. It helps get this information to more people who need it. And make sure you subscribe to Legal Loophole US. We are posting new deep dives every single week. I'm Mike. Stay safe, stay smart, and know your rights.